Hey everybody, I remember my first year law school, and I'm here to get you through all your cases. It's important to read your cases at least once, and now I'm here to read them for you so you can learn your cases on your free time. Please remember to subscribe and tell your friends about these videos. Now let's get started. The first case is Lucy v. Zehmer. This suit was instituted by W.O. Lucy and J.C. Lucy. Complainants against A.H. Zehmer and Ida S. Zehmer, his wife, to have specific performance of a contract by which it was alleged that Zehmers had sold to W.O. Lucy a tract of land owned by A.H. Zehmer known as Ferguson Farm for $50,000. J.C. Lucy, the other complainant, is brother of W.O. Lucy, to whom W.O. Lucy transferred half interest in the alleged purchase. The instrument sought to be enforced was written by A.H. Zehmer on December 20th, 1952, in these words: "We hereby agree to sell to W.O. Lucy the Ferguson Farm, complete for $50,000, title satisfactory to the buyer, and signed by the defendants A.H. Zehmer and Ida S. Zehmer." The answer of A.H. Zehmer admitted that at the time mentioned, W.O. Lucy offered him $50,000 cash for the farm, but that he, Zehmer, considered that offer was made in jest. That so thinking, and both he and Lucy having had several drinks, he wrote out the memorandum quoted above and introduced his wife to sign it. That he did not deliver the memorandum to Lucy, but that Lucy picked it up, read it, put it in his pocket, attempted to offer Zehmer $5 to bind the bargain, which Zehmer refused to accept, and realizing for the first time that Lucy was serious, Zehmer assured them that he had no intention of selling the farm and that the whole matter was a joke. Lucy left the premises insisting that he had purchased the farm. Depositions were taken, and the decree appealed from was entered holding that the complainants had filed and established their right to specific performance and dismissing their bill. The assignment of error is to this action of the court. W.O. Lucy, a lumberman and farmer, thus testified in substance. He had known Zehmer for 15 to 20 years and had been familiar with the Ferguson farm for 10 years. 7 or 8 years ago, he had offered Zehmer $20,000 for the farm, which Zehmer had accepted, but the agreement was verbal and Zehmer backed out. On the night of December 20th, 1952, around 8 o'clock, he took an employee, McHenry, where Zehmer lived and operated a restaurant, filling station, and motor court. While there, he decided to see Zehmer and again tried to buy Ferguson Farm. He entered the restaurant and talked to Mrs. Zehmer until Zehmer came in. He asked Zehmer if he had sold Ferguson Farm. Zehmer replied that he had not. Lucy said, "I bet you wouldn't take $50,000 for that place." Zehmer replied, "Yes, I would, too. You wouldn't give me 50. Lucy said he would and told Zehmer to write up an agreement to that effect. Zehmer took the restaurant check and wrote on the back of it, "I do hereby agree to sell W.O. Lucy the Ferguson Farm for $50,000 complete." Lucy told him he had better change it to "we," because Mrs. Zehmer would have to sign it too. Zehmer then tore up what he had written, wrote an agreement quoted above, asked Miss Zehmer, who was at the other end of the counter, 10 or 12 feet away, to sign it. Mrs. Zehmer said she would for $50,000 and signed it. Zehmer brought it back and gave it to Lucy, who offered him $5, which Zehmer refused, saying, "You don't need to give me any money. You got the agreement here signed by both of us." The discussion leading to the signing agreement said Lucy lasted 30 or 40 minutes, during which Zehmer seemed to doubt that Lucy could raise $50,000. Lucy suggested the provision for having title examined, and Zehmer made the suggestion that he would sell it complete, everything there, and stated that all he had on the farm was 3 heifers. December 20th was on a Saturday. The next day, Lucy telephoned to J.C. Lucy and arranged with the latter to take half interest in the purchase and pay half of the consideration. On Monday, he engaged an attorney to examine the title. The attorney reported favorably on December 31st, and on January 2nd, Lucy wrote Zehmer stating that the title was satisfactory, that he was ready to pay the purchase price in cash, asking when Zehmer would be ready to close the deal. Zehmer replied by letter mailed on January 13th, asserting that he had never agreed or intended to sell. Mr. and Mrs. Zehmer were called by the complainants as adverse witnesses. Zehmer testified in substance as follows. He bought this farm from more than 10 years ago for $11,000. He had 25 offers more or less to buy it, including several from Lucy, who had never offered any specific sum of money. He had given them all the same answer, that he was not interested in selling it. On this Saturday night, before Christmas, it looked like everybody and his brother came by there to have a drink. After they had talked for a while, Lucy asked whether he still had the Ferguson farm. He replied that he had not sold it, and Lucy said, "I bet you wouldn't take $50,000 for it." Zehmer asked him if he would give $50,000, and Lucy said yes. Zehmer replied, "You haven't got $50,000 in cash." Lucy said he did, and Zehmer replied that he did not believe it. They argued pro and con for a long time, mainly about whether he had $50,000 he could put right then and there to buy the farm. "Finally," said Zehmer, "Lucy told him if he didn't believe that he had $50,000, you sign the piece of paper here and say you will take $50,000 for the farm." He, Zehmer, just grabbed the back of the guest check there and wrote on the back of it. At that point, testimony of Zehmer asked to see what he had written to see if he recognized my own handwriting. He examined the paper and exclaimed, "Great balls of fire! I got Ferguson for Ferguson. I have got satisfactory spelled wrong. I don't recognize that writing. I would see it. I wouldn't know it was mine." After Zehmer had, as he described, scribbled things off, Lucy said, "Get your wife to sign it." Zehmer walked over where she was, and she at first refused to sign, but did so after he told her he was just needling him and did not mean a thing in the world, that I was not selling the farm. Zehmer then took it back to over there, and I was still looking at the darn thing. I had the drink right there by my hand, and I reached over to get the drink, and he said, "Let me see it." He reached, picked it up, and when I looked back again, he had it in his pocket and dropped a $5 bill over there, and he said, "Here's $5 payment on it." I said, "Hell no. That is the beer or liquor talking. I am not going to sell you the farm. I have told you that too many times before." Mrs. Zehmer's testimony was similar to her husband's testimony. She did add that after Lucy said, "All right, get your wife to sign it," Zehmer came back where she was standing and said, "You want to put your name onto this?" She said no, but he had said in an undertone, "It's nothing but a joke," and she signed it. The defendants insist that the evidence was ample to support their contention that the writing sought to be enforced was prepared as a bluff or a dare to force Lucy to admit he didn't have $50,000, that the whole matter was a joke, that the writing was not delivered to Lucy, and no binding contract was ever made between the parties. It is an unusual, if not bizarre, defense. When made to the writing admittedly prepared by one of the defendants and signed by both, clear evidence was required to sustain it. In his testimony, Zehmer claimed that he was high as a Georgia pine, and that transaction was just a bunch of two doggone drunks bluffing to see who could have the biggest and say the most. The record is convincing that Zehmer was not intoxicated to the extent of being unable to comprehend the nature and consequences of the instrument he executed, and hence that the instrument is not to be invalidated on those grounds. The evidence is convincing also that Zehmer wrote two agreements, the first one beginning, "I do buy, agree to sell." Zehmer first said he could not remember about that, then that "I don't think I wrote that but one out." Mrs. Zehmer said that what he wrote was "I hereby agree," but that the "I" was changed to "we" after that night. The agreement that was written and signed is in the record that indicate no such change. Neither are the mistakes in spelling that Zehmer sought to point out repeatedly apparent. The appearance of the contract, the fact that it was under discussion for 40 minutes or more before it was signed, Lucy's objection to the first draft because it was written in a singular, and he wanted Mrs. Zehmer to sign it also, the rewriting to meet the objection and the signing by Mrs. Zehmer, the discussion of what was included in the sale, the provision for examination of the title, the completeness of the instrument that was executed, the taking possession of it by Lucy, which no request or suggestion by either of the defendants that he gave it back, are facts that furnish persuasive evidence that the execution of the contract was serious business transaction rather than a casual jesting matter, as the defense now contends. If it be assumed to the contrary to what we think the evidence shows, that Zehmer was jesting about the selling of his farm to Lucy, and that the transaction was intended by him to be a joke, nevertheless the evidence shows that Lucy did not understand it, but considered it to be a serious business transaction, and that the contract to be binding on the Zehmers as well as on himself. Not only did Lucy actually believe, but the evidence shows he was warranted in believing that the contract represented a serious business transaction and a good faith sale and purchase of the farm. In the field of contrast, as generally elsewhere, we must look into the outward expression of the person manifesting the intention rather than his secret and unexpressed intention. The law imputes to a person an intention corresponding to the reasonable meaning of the words and acts. At no time prior to the execution of the contract had Zehmer indicated to Lucy by word or act that he was not earnest about selling the farm. They had argued about it, discussed its terms, as Zehmer admitted, for a long time. Lucy testified that if there was any jesting, it was about the paying of $50,000 that night. The contract and the evidence shows that he was not expected to pay the money that night. Zehmer said that after the writing was signed, laid it down on the counter in front of Lucy. Lucy said Zehmer handed it to him. In any event, there had been what appeared to be a good faith offer and a good faith acceptance, followed by an execution and apparent delivery of a written contract. Both said that Lucy put the writing in his pocket and then offered Zehmer $5 to seal the bargain. Not until then, even under the defendant's evidence, was anything said or done to indicate that the matter was a joke. Both of the Zehmers testified that when Zehmer asked his wife to sign it, he whispered that it was a joke so Lucy wouldn't hear, and that it was not intended that he should hear. If the words or acts of one of the parties have but one reasonable meaning, this undisclosed intention is immaterial except when it is unreasonable, meaning that he attaches his manifestations is known to the other party. An agreement or mutual assent is of course essential to a valid contract, but the law imputes to a person an intention corresponding to the reasonable meaning of his own words or acts. If his words and acts judged by a reasonable standard manifest an intention to agree, it is immaterial what may be the real but unexpressed state of mind. So a person cannot set up that he was merely jesting when his contract and words would warn a reasonable person to believe that he intended a real agreement. Whether the writing signed by the defendants and how sought to be enforced by the complainants was the result of a serious offer by Lucy and a serious acceptance by the defendants, or was a serious offer by Lucy and an acceptance in secret jest by the defendants. In either event, it constituted a binding contract of sales between the parties. The complainants are entitled to have specific performance for the contract sued on. The decree appealed from is therefore reversed and cause is remanded for the entry of a proper decree requiring the defendants to perform the contract in accordance with the prayer of this bill. Reversed and remanded. Now, for the rest of this case, I would suggest reading your case briefs that either you can do or you can get them online. But it's just important that you read the cases first, just for familiarity with kind of the stuff that could come up in class. But other than that, have a great day.